Hey everyone, welcome back to Corporate Decoder. Today, LUNAI Bioworks just filed a major acquisition announcement. It's an 8K that reveals a big shift in their assets. Quick note, this is not financial advice, just my take on public filings for educational purposes. This filing details a significant acquisition of intellectual property and the issuance of new preferred stock, which seems tied to keeping the company listed on the Nasdaq. Alright, so this is a current report from LUNAI Bioworks filed on May 1st, 2026. Think of it like a news flash for investors. The big story here is that LUNAI Bioworks has completed a merger, which is basically a fancy way of saying they bought another company or a significant part of it. This company, LUNAI Bioworks, is in the healthcare and biotech space. It's a smaller company with a market cap around $12 million and 29 employees. They have been in the news recently for a few reasons, including a potential reverse stock split, which is when a company reduces its number of outstanding shares to boost its stock price. The main point of this filing is to tell everyone about a material definitive agreement. Material basically means important. So on the 27th of April 2026, LUNAI Bioworks entered into an agreement to merge with another company. The company they merged with is called Neurobridge IP Holdings Incorporated. Now, Neurobridge didn't really have much going on except for a patent portfolio. Think of this as a collection of inventions and exclusive rights to use them. LUNAI Bioworks also involved its own subsidiary, LUNAI Bioworks IP Incorporated. And the sellers of these patents were Oncotelic Inc. and Pelerin Therapeutics Inc. So what happened? Neurobridge IP Holdings, which was owned by Oncotelic and Pelerin, merged into LUNAI Bioworks IP. This is called a triangular merger. Essentially, LUNAI Bioworks ended up with the patents from Neurobridge, and Neurobridge's previous owners got paid in a special kind of stock from LUNAI Bioworks. This whole deal closed on May 1st, 2026. And what exactly did LUNAI Bioworks acquire? It's a patent portfolio. Specifically, they got patents related to heterocyclic compounds for treating Alzheimer's disease, and also patents for treatments involving anti-TGF-beta agents, Apomorphine formulations, and delivery technologies for neurological disorders. This sounds like cutting-edge stuff in the neuroscience and drug development world. The company mentioned they will evaluate these patents for their central nervous system research and development programs. Now let's talk about how they paid for this. They did not pay any cash. Instead, on May 1st, 2026, LUNAI Bioworks issued 8 shares of a new type of stock called Series B Convertible Preferred Stock to the sellers. This preferred stock has a stated value of $20 million. Oncotelic received 5 shares worth $12.5 million. And Pelerin received 3 shares worth $7.5 million. This Series B preferred stock is interesting. It can be converted into regular common stock, but there are some important conditions. First, it requires stockholder approval from LUNAI Bioworks shareholders. This approval is not needed for the merger to happen, but it is needed to convert the preferred stock into common stock. The conversion price is set at $1.5 per S-share, meaning if it converts, it could potentially create about 13.3 million new shares of common stock for the holders of the preferred stock. This means that the real value of these preferred shares in terms of potentially boosting the number of common shares is locked until the shareholders say yes. The company has promised to try and get this shareholder approval as soon as reasonably possible, within 180 days after the merger. Importantly, there is a special clause that says if they fail to get stockholder approval, there won't be any penalties like increased stock value or new fees for the company. This seems to be a way to comply with Nasdaq rules related to shareholder approval for certain issuances. Also, this Series B preferred stock does not come with voting rights, no dividends, and it cannot be redeemed by the holders. It also doesn't have protection against price drops, which is pretty standard for this type of deal. The company is saying this issuance does not count as a change of control, which is significant for regulatory purposes. There is also a limit on how much of the company's stock a single holder can own through conversion. It's set at 4.99%, but a holder can increase this to 9.99% with advance notice, and further increases would need the company's permission and a review by Nasdaq. This is a common way for companies to prevent a single investor from taking too much control through conversion of preferred stock. This is a really interesting part. The company can use the Series B preferred stock or common stock if it is already converted to satisfy any indemnification claims against the sellers. Indemnification means if the sellers, Oncotelic and Pelerin, are found responsible for something later on. LUNAI Bioworks can take back some of the stock they issued. There is also a special IP clawback if the patents they acquired turn out to be invalid or unenforceable. This means if the core of the deal falls apart due to patent issues, LUNAI Bioworks has a way to claw back some of the value. The Series B preferred stock and any common stock it converts into are considered restricted securities. This means they cannot be freely traded on the stock market easily. They will have special markings or legends on them that show they are restricted. Also, they will not be easily transferable through systems like DTC, the Depository Trust Company, until these restrictions are removed. Pelerin, the Canadian company, has an additional Canadian legend with a hold period of 4 months after the issue date. The sellers, Oncotelic and Pelerin, have agreed to indemnify LUNAI Bioworks. This means they will cover certain potential losses, but their responsibility is limited. It's on a pro rata basis based on their ownership. There is a deductible, meaning the first certain amount of losses is not covered, and there is a general cap. But for more serious issues like fraud, there is no cap. They also agreed to not challenge the patents they sold and other non-disclosure clauses. Let's go back to these patents, as they are the core of the acquisition. The Pelerin patent family focuses on heterocyclic compounds for Alzheimer's treatment. The Oncotelic patent family is broader, covering anti-TGF-beta agents, Apomorphine formulations, and delivery methods for neurological problems like Parkinson's and Alzheimer's. The company mentions specific patent numbers and application details here, but the key takeaway is that these are patents in the medical field. Here is something interesting. LUNAI Bioworks is saying that this acquisition does not count as acquiring a business. This is important because if it were considered a business acquisition, they would have to provide extensive historical financial statements for the acquired entity. By saying it is not a business, they are essentially saying they only acquired intellectual property, not an ongoing operation with employees, customers, or revenue. This simplifies their financial reporting obligations for this deal. This section just confirms that the merger happened on May 1st, 2026. It reiterates that the main assets acquired were the patents, and that the acquired entity had no operations, employees, or revenue. The payment was the $20 million Series B preferred stock. This part is crucial for understanding why this deal likely happened. LUNAI Bioworks received a notification from Nasdaq that they were at risk of being delisted. Specifically, they were not meeting the requirement for at least $2.5 million in stockholders' equity. They asked for an extension to prove they've met this requirement. Then on May 1st, 2026, they completed the merger and issued that $20 million Series B preferred stock. They believe this transaction and how the Series B stock is accounted for will push their stockholders' equity above the $2.5 million minimum required by Nasdaq. This looks like a strategic move to satisfy Nasdaq's listing requirements. However, they are still waiting for Nasdaq's final decision. There is no guarantee that Nasdaq will agree that they have met the requirements. This section confirms the issuance of the Series B preferred stock to Oncotelic and Pelerin. It clarifies that this stock was sold privately, meaning it wasn't offered to the general public, and that it was done under an exemption from registration requirements. This is common for these types of acquisition deals. The sellers represented that they are accredited investors and are buying for investment purposes only, not to resell immediately. This statement notes that issuing the Series B preferred stock might change the rights of existing common stockholders. Specifically, in case the company dissolves, the preferred stockholders get paid first up to their $20 million stated value. It also highlights the potential future dilution if the preferred stock is converted into common stock. This section simply states that the company filed the official document that creates the Series B convertible preferred stock with the Delaware Secretary of State. This filing becomes effective upon filing and formally defines the terms and rights of this new stock. As mentioned earlier, because the company claims this wasn't the acquisition of a business, but rather just intellectual property, they are not providing financial statements of the acquired entities. This is a key point that simplifies the filing. This exhibit is the actual merger agreement. It is a detailed contract that lays out all the terms and conditions of the deal. This exhibit is the Certificate of Designation for the Series B convertible preferred stock, the document that officially creates and defines this new stock. The company is also talking about a special meeting of stockholders scheduled for May 8th, 2026. One of the key proposals at this meeting will be a reverse stock split. This is intended to help the company comply with another Nasdaq rule, the minimum bid price requirement, which means the stock price needs to be at least $1. The merger and the preferred stock issuance help with the equity requirement, but they don't fix the low stock price problem. So the reverse split is still necessary. This section points investors to where they can find more detailed information, like the company's proxy statement, which lists all the proposals for the special meeting. And finally, the forward-looking statements. This is a standard legal disclaimer. It warns investors that any statements about future expectations, plans, or beliefs are not guarantees. They mention risks like Nasdaq not accepting the merger as a solution for the equity rule, potential accounting differences affecting the equity calculation, the possibility of the reverse stock split failing, and importantly, the risk that the acquired patents might not be valid or enforceable. This is where the company is telling you that while they are optimistic, things could go wrong. So, what is my take on this? LUNAI Bioworks is in a bit of a tight spot, trying hard to stay listed on the Nasdaq. They've made a strategic acquisition of intellectual property, which could be valuable long term, and they've issued a significant amount of preferred stock to pay for it. The primary driver for this deal seems to be meeting Nasdaq's equity requirement, not necessarily the immediate growth potential of the acquired patents. The fact that they don't consider it a business acquisition is a clever regulatory maneuver that simplifies their reporting, but also means we don't get a look at the financials of what they bought. The Series B preferred stock has complex terms, including a conversion gate tied to shareholder approval and IP clawback provisions, which add layers of risk and potential for future dilution or disputes. The biggest risk I'm watching is whether Nasdaq will accept this preferred stock issuance as sufficient to keep the company listed. If not, they face delisting, which would severely impact their stock. The other major risk is the validity and commercial success of the acquired patents. They are acquiring patents for Alzheimer's and other neurological diseases, which are incredibly competitive and high-risk areas. The reverse stock split proposal at the upcoming shareholder meeting is also a concern, while necessary for the bid price rule. These splits historically do not guarantee long-term success for struggling smaller companies. In fact, historically about half of micro-cap companies that do reverse splits end up delisted anyway. Similar to the pattern we saw with Kodak's 2021 1-for-20 split, which in retrospect was a precursor to further stock price declines. My biggest concern is that this entire transaction may be more about survival on Nasdaq than about building sustainable long-term shareholder value through operational growth and innovation from the acquired IP. The company appears to be using financial engineering rather than purely business growth to stay afloat. The research tools I actually use are linked in the description. They help keep this channel going. That is my take. Stay decoded. If this analysis was valuable, hitting that like button really helps, and subscribe for more deep dives. Don't forget to check out the Discord in the description.